The National Prosecuting Authority is now asking the Constitutional Court to reject a last-ditch attempt by former President Jacob Zuma to avoid prosecution. NPA prosecutor Billy Downer says Zuma has failed to back up his claim that the 15-year delay in the case against him will result in the former president not getting a fair trial. Zuma also claims that the charges against him were motivated by a political conspiracy, but Downer says in court papers that Zuma has done nothing to prove these claims. Zuma wants to appeal the ruling delivered by the Pietermaritzburg High Court last year, in which 3 judges rejected the same argument. Last month, the Supreme Court of Appeal dismissed Zuma's attempts to challenge the Pietermaritzburg decision, saying that it had no reasonable prospects of success. Karyn Maughan is our editorial contributor. She joins us now. Karyn, good afternoon to you. All right, just from looking at that, it seems like this is quite a stinging argument, an affidavit, I presume, filed by Billy Downer here.
Yes, I mean, Billy Downer, as you well know, having covered the case yourself, has been the long-term prosecutor in the case against Jacob Zuma. Himself, as we recall, being the target of allegations by Zuma, that he had somehow was longing for the days of apartheid-era prosecutions, etc., in a number of amendments that the EPA then successfully managed to get struck from the record, the court record. But essentially displaying a huge degree of impatience in this particular affidavit, in which he simply says that he regards this application by Jacob Zuma as not being, not having any reasonable prospects of success on appeal, not raising any important issues of justice that need to be decided, or, areas that would justify the court now getting involved at this point. And lastly, just simply saying that this is part of the so-called stubborn grab strategy of litigation, which he says has been employed by Zuma in response to the corruption case against him, which we know has been dragging on and off again for the last 15 years, and that the court shouldn't even hear it.
I mean, he seems to be suggesting, it would be quite something for the Constitutional Court to deny an appeal without hearing it, although, in this case in particular, they've started to do that more and more often.
Well, I think the key thing here is that the Supreme Court of Appeal literally refused to hear the arguments on this case and said quite categorically that there was no reasonable prospect of success in another court, also finding that there were no novel legal issues that would justify that in the interest of justice hearing this appeal. So already Jacob Zuma coming in as somewhat of a disadvantage, and the key point here is that the state has continually said, and this particular argument has been supported by multiple court rulings given over the years, that the kind of complaints that Jacob Zuma raises are things that can be dealt with in the trial court. So if he has, beliefs that this case against him is fundamentally tainted by political interference, he can raise that in the case. If he can't remember crucial details because of the lapse of time, he can raise that in the case. So, him now needing, Billy Downer saying that preliminary litigation aimed at stopping a criminal trial before it even goes ahead cannot be tolerated by the highest court in the country, and they must dismiss this application out of hand.
Okay, so the Constitutional Court judges will look at this case. They'll make a decision. If they go with the Supreme Court of Appeal, reject the arguments from the former president, what happens after that? I mean, could there be other applications that are filed? Could a trial actually begin?
Stephen, this is literally, as far as I'm concerned, the last application that can be made. I mean, unless there was some kind of attempt to review the decision by Sean Abrams to go ahead with this case, but that would not be a successful one given the huge deluge of court judgments that have come before that. And this is the difficulty for Jacob Zuma. Essentially, in bringing the multiple court applications that he has not only shored up the admissibility of a number of crucial pieces of evidence against him, including the 93,000 documents that the NPA secured in raids conducted by the Scorpions in 2005, but also mutual legal assistance, etc., etc., etc. And the courts have continually had the same attitude that he can raise these complaints that he has in his trial court. He's due back on the 6th of May in the court. He'll, of course, have to address this issue of the problems with the sick note presented by his lawyers as reasons for him not being there. But the attitude of the state, and Billy Downer says it in as many words, is that they are ready to proceed. They have the forensic evidence only one of the witnesses in this case has passed away. All the other witnesses are available, and the state is ready and willing to persist with its prosecution.
I imagine that would mean we'd all go back to Durban or Pietermaritzburg for the start of this case. It would be quite a trial if it actually gets going.
Absolutely. And I mean, this is the big issue of course, which is, also before the Supreme Court of Appeal, is the issue of Jacob Zuma's legal funding. We know that the Pretoria High Court finding that he was not entitled to the over 16 million rand already spent by the state on litigation, all the matters, challenges to the raise, challenges to the mutual legal assistance request, etc., etc., etc. He now has to pay back that money, and he's not entitled to any further legal funding of his defense costs, which means he's going to have quite a profound difficulty if this trial runs, given that it's projected to run for a year, given the millions of rands that will be required to fund it, and given that, he appears to be in quite a dire financial situation, how exactly he will get the money that he needs to defend himself, or how he will manage to do that. And I think that's one of the most pressing issues that his lawyers may raise when this case returns to court on the 6th of May. Even if the Constitutional Court does reject this appeal, they will then say, well, this funding issue is still before the SCA, and that's a reason to delay for an even longer period.
Karyn Maughan, thanks very much indeed, editorial contributor here at Newzroom Afrika.